Warm welcome to the seminar, all of you. And this seminar, as you know, is organized by the Swedish Foundation for Human Rights, together with the Nordic Institute of Latin American Studies. My name is Sofia Ekar from the Swedish Foundation for Human Rights, and I will be moderating this seminar today. And by my side, at least virtually, I have Felicia and Jay Högren, who will be supporting me with some technical features. And in this webinar, we will be discussing the regional Inter-American human rights system and its impact on human rights, peace and security in the Americas. And this was also the theme for the second essay competition that we at the Swedish Foundation for Human Rights organized this year for bachelor and master students. And while last year's competition examined the African system for human rights and its importance for peace and security in Africa, this year we focused on the Americas and the Inter-American human rights system. And therefore today we have the three finalists of the competition who will be presenting their areas of study and some conclusions. And our finalists are Amalia Idefelt-Hamnell, Lovisa Corelius, and Helme Jonelid, who all study law at Uppsala University. And we are also very pleased to be joined by our expert panel, who will be discussing the role of the Inter-American system for human rights, peace and security in the Americas. And our panelists are Andres Rivarola Puntigliano, Director of the Nordic Institute of Latin American Studies, Diego Rodriguez Pinzon, Professorial Lecturer in Residence and Co-Director of the Academy on Human Rights and Humanitarian Law at the American University, Washington College of Law. And our third member of the panel is Per Engström, Senior Lecturer in Human Rights at the Institute of the Americas, University College of London. And Diego and Per were also, together with myself, part of the jury for the essay competition. And before closing the seminar today, we will be presenting the winner of the competition. I would like to encourage you all to post your questions in the chat, and I will pick the questions up towards the end of the seminar. I would also like to notify you that we will ask you to complete a short survey at the end of the seminar, and we will post the link later on. And finally, before we dig into the presentations and discussions of today, I would like to hand over to my co-organizer, Andres, Director of the Nordic Institute of Latin American Studies, with a few introductory words.
Thank you very much, Sofia. First of all, hello to all the participants, to Per and Diego and all the students that have done this great job. Congratulations for all. And a particular thanks for you, Sofia, to have organized all this, you and the Swedish Foundation for Human Rights, and invited the Institute to participate. And I'm really happy about this. One, because the theme is very important. And also, although we are an Institute of Latin American Studies, the issue of the American and the hemispheric dimension is, of course, very important to us. Just to remind everybody, we in Sweden, the Institute and other people in Sweden have been part of the, for example, the International Congress of Americanists. That is one of the oldest academic regional organizations that still have their conferences and has been going on since 1875. So this is only one of the dimensions, America-related dimensions where we are active, and we are happy that this interest continue among scholars at universities and organizations such as the Swedish Foundation for Human Rights. So thank you very much for inviting us to participate here.
Thank you so much, Andres. I think we're now ready to kick off this webinar with a short introduction of the Inter-American human rights system, which will be given by Diego Rodriguez Pinzon. Diego, the floor is yours.
Thank you very much. First of all, thank you very much for the two institutions, organizers of this initiative, and congratulate you because I think it's extremely important for not only academic work, but also advocacy work. I want to thank the Swedish Foundation for Human Rights and, of course, the Nordic Institute of Latin American Studies. And I have been invited to talk a little bit very briefly about the Inter-American human rights system. And I'd like to make a very, very quick reference on the historic structure of the Inter-American system to understand more or less in temporal terms how this system inserts in the international community. First of all, just to mention the Organization of American States, which is the basis, which is the institution under which the auspices we have the Inter-American human rights system, was established in 1948 through the charter of the organization. We are talking about 3 years after the war. We are talking about that precise moment in which we had across the Atlantic the development of the European human rights system, and of course the creation and consolidation of the United Nations and its tools. So think about that very precise moment in time, because we have the Organization of American States, and simultaneously that same year, at the same time which the institution was created, we have the adoption of the American Declaration on Human Rights. And I like to use that notion, even if it's not the term of art or the appropriate name. The declaration, not the convention. American Declaration on Human Rights, 1948, an aspirational instrument adopted by states simultaneously with the creation of the OAS. It's important to bear that in mind when we talk about the Inter-American system. But not until 1959, we have the creation of the first institutional mechanism of promotion and supervision of the Inter-American system, the Inter-American Commission on Human Rights, created by an ad hoc meeting of plenipotentiary ministers that gave mandate to the commission, created a structure, established its statute, and from 1960, which was when the commission began to work in its first session, this organ has been one of the main mechanisms of promotion and supervision of human rights obligations in the Inter-American system. But that first moment, again, we are talking about 1959, 1960, it had a very soft mandate, a very soft legal background or underpinning. So a very important moment in the development of the Inter-American system, it's its elevation, if you want, to a principal organ of the Organization of American States under the Charter. And that happened in 1967 under the Protocol of Buenos Aires. That really brought the Inter-American Commission into the heart and the mainstream of the organization, and again, giving it a specific character of principal organ of the OAS. Again, you compare that with the High Commissioner of Human Rights in the UN system, and others, to a certain extent, plays that role also, as we'll see in a second. So these are two very important moments regarding the consolidation of the main mechanism of promotion and supervision of the Inter-American system under the Charter of the OAS. But a second very important moment, of course, has to do with the adoption and entry into force of the American Convention on Human Rights, the multilateral treaty, the binding instrument on human rights in our hemisphere. And in this sense, we are talking about 1969 in adoption, and then a decade later, 1978, entry into force of the American Convention on Human Rights, and therefore, under the auspices of this instrument, the creation of the Inter-American Court on Human Rights. So this completes, to a certain extent, the institutional structure and framework of supervision of the Inter-American system. The court was then established in 1980 and began its functioning until now. Both organs integrated by 7 members. The commission, 7 commissioners, the court, 7 judges. They are all working in a part-time basis, mostly ad honorem designations. That's what we had in 1960, 1959, 1960 in the commission. That's what we had in 1980 in the court, and that's what we have today. We have not seen any evolution in this regard. Commensurate to that has the financial implications, the budget allocated. It would be a broader discussion about it, but think about, that these organs are more or less less than 10% the budget of the Organization of American States. I would say that if you compare it with the European Court on Human Rights, which amounts, I understand, to 90 million euros, we are talking about $10 million in the Inter-American human rights system, more or less, depending how you count the funding that these mechanisms receive for a hemisphere, as you can imagine, a hemisphere of more than 800 million people. The commission, let me talk about the powers very briefly. The Inter-American Commission on Human Rights, as the principal organ of the OAS, has a very broad mandate. has an extremely broad mandate that has evolved throughout the years in the Inter-American system through practice of this organ confronting in the different stages of political environment in the hemisphere, different stages of development. The Commission overall had to confront, particularly at the end of the 60s, in the decade of the 70s, the authoritarian regimes that emerged in many countries of the region. And this really framed a lot of the things that the Inter-American Commission does until now. The Commission developed very important tools that were in place since its creation regarding, for example, the possibility of performing on-site visits, the possibility of issuing reports regarding country situations, these promotional and political aspects, if you want, of the mandate of the Commission were in place and were really developed, really were a very important tool in confronting mass systematic violations of human rights in these authoritarian regimes, dictatorships, juntas, etc. So keep in mind that the Commission has been shaped in this conversation with dramatic situations in many countries of the hemisphere. That said, in subsequent stages of development, the Commission has evolved and mutated many of its tools because of the changing hemisphere. If you think about the transitional processes that have taken place in several countries of the region, from dictatorships to democracy, from civil war to peace, these changes, dramatic changes that began to occur in the 80s and 90s in this hemisphere, has taken the Commission to engage in a more legal conversation with states in which have more embryonic, emerging democratic regimes. You have democratic systems, precarious democratic systems in some of these countries that were trying to evolve into these representative democracies with separation of powers, and again, a quite weak judiciary, but a judiciary that the Commission in particular and the court have considered extremely important in the promotion and protection of human rights inside of these countries. Other tools of the Inter-American system and of the Commission, the promotional aspect, deal with the possibility of supervising through rapporteurs. This is something that has evolved in the latest stages of development of the Commission. And furthermore, the creation of groups of supervision, interdisciplinary groups, very specific tools such as the MESEVE, the monitoring mechanism for Venezuela, the monitoring mechanism for Nicaragua, so on and so forth. These latest tools have proved to be a very interesting development in the latest stages of work of the Inter-American Commission. And also, and you can visit the Commission's website, the statements, if you want, press releases and positioning of the Inter-American Commission that allows it to react in real time to many of the situations that are taking place in the hemisphere. That's the promotional package if you want. Then you have the protection package, which is the cases, the complaints, a very important tool that goes hand by hand with the other organ of the Inter-American system, the Inter-American Court on Human Rights. The case system of the Inter-American Commission has been enhanced in this latest stage of development, this post-dictatorship or stage of the hemisphere, in which the legal conversation has proven to be more important. And in that sense, we have seen an evolution both in the Commission and the court, a legal treatment, more legal treatment, and judicial treatment in the Commission, and of course, the Inter-American Court beginning to play a crucial role in this conversation. The Inter-American Court on Human Rights, again, and the Commission can deal with individual complaints and with interstate cases. Very few interstate cases, but there have been also other aspects of the work of the Commission and the Court that I think are extremely important when we get into the conversation about how the system deals with gross systematic violations of human rights that could merit a collective response of protection, and that's interim measures. And I'd like to really call your attention to the interim measures of the Inter-American Commission and Court, the precautionary measures of the Commission, the provisional measures of the Inter-American Court, because these measures are able to be triggered beyond the formal individual case framework that traditionally informs other international adjudicatory mechanisms in the human rights world, Europe, UN, etc. These other mechanisms work within the realm of cases that have been filed and maybe at least prima facie admissible. It means that exhaustion is at least arguable in those cases. In the case of the interim measures of the Inter-American system, you can request a measure of this nature before the Commission, even before you have a plausible case that you could file before the Inter-American system. So it is an autonomous tool. It really works in a real-time basis, which is very important, as you can imagine, from the perspective of prevention of violations of human rights. So the interim measures of the Inter-American system are not there just to preserve the status quo in litigation, but it goes far beyond. It is an autonomous tool that serves the purpose of protecting victims from violations under the Declaration and Convention. Keep that in mind, because again, this shows what type of development we've had in the Inter-American system that maybe has not taken place in other regions of the world or in the UN system for different reasons. I'm sure that we're going to be discussing in this conversation some of these aspects regarding, of course, the notion of the duty to protect or the responsibility to protect that states have in the Americas. I would continue talking about a couple of issues, the issue of reparations, that it has on its own very important aspects in the structural changes in countries beyond just the satisfaction of the rights of individuals in the cases, trying to prevent by changing structures and other characteristics of the system. I'm sure that we'll be able to touch upon them. I think I have gone beyond my allocated time, so I apologize and thank you for your attention.
Thank you so much, Diego. I think your presentation gave us a good background and information needed to further explore the system and its impact on human rights, peace, and security in the Americas. I am now virtually directing myself towards Amalia, one of our finalists in the essay competition. Amalia, in your essay, you have looked closer at the role of the court and how the court has contributed to human rights protection in Latin America. And would you like to tell us a little bit about what you've studied and found?
Yes, of course. Well, first of all, I want to thank you for organizing this essay competition. I think it's a great way of engaging students in the areas that you work within. And also it's a great possibility for us to devote ourselves a little bit more to the subject. So thank you for that. And thank you for setting up this webinar today. I'm very excited to hear all of the participants that are here today. So the subject of my essay, as you said, is the Inter-American Court, specifically of human rights, which is the judicial organ of the system. And the starting point, basically, of my essay is the fact that the court struggles with quite low compliance rates and have been for a long time. So as of the end of 2019, the court announced that only 13.5% of its rulings had actually been fully complied with. So what I wanted to explore in my essay was how the court can be said to contribute to human rights protection in Latin America, despite these rather discouraging numbers. And what I found is, when looking into these numbers, is that the court's method of ordering reparations from the state's parties is quite extensive. They usually issue a very long and detailed list of measures that they want the state to comply with. And consequently, states rarely achieve all of these measures. However, that doesn't mean that states usually do nothing at all after a ruling of the court. So because of the wide range of reparations that they use, there are also big differences in compliance in between them. And several scholars have noted that some of the measures are actually complied with in relatively high numbers, such as economic or symbolic compensations to the victims of a human rights violation. And this is, of course, important, since it shows that in many cases, the actual victim is given some kind of reparation after a court's ruling. On the other hand, we see that measures which demand more of a structural change within states, such as prosecution of individual human rights perpetrators or the reform of laws or institutions, are complied with in relatively low numbers or very low numbers. And these flaws should be seen, and this Diego talked about a bit as well, they should be seen against the background of the post-dictatorship context which the court operates within, and the high levels of impunity and corruption that still exist in large parts of Latin America today. What is worrying, though, is of course that these measures are such structural reforms that are necessary and crucial in order to achieve more of a long-term human rights protection and in order to prevent future violations from happening. So seeing as the court is primarily struggling to achieve compliance with these more far-reaching measures, it doesn't go to show that the court cannot contribute at all in this regard. And that is because one should also consider some of the extra compliance effects that the court can have. That is, the effects of the court's rulings that reach beyond compliance in the individual cases. Firstly, one should note that the Inter-American Court has a direct influence on domestic courts, which are becoming an increasingly important arena for human rights politics in Latin America. And as the American Convention obliges domestic courts to follow the Inter-American Court's interpretations of the same document, the effects of its rulings, of course, reach into the judiciary of many more states than use the state party in question. One example is the Supreme Courts of Uruguay and Chile that, for example, have shown eagerness to use existing interpretations of the American Convention in order to repeal amnesty laws that hindered investigation of very gross human rights violations, which happened during the dictatorship eras. And of course, not all domestic courts are as eager to engage in human rights protection. One example being the Supreme Court of Brazil, which have been resistant to adopting the Inter-American Court's interpretations overall. But apart from the domestic courts and the judiciary function, these extra compliance effects have also been shown to have a great influence and to strengthen domestic human rights mobilization on the ground in Latin American countries. Human rights organizations are dominant in bringing cases before the court, and studies suggest that this form of litigation also serves the purpose of reaching beyond compliance in the individual case and beyond reparation of the victim in question. So with the case law of the court, domestic human rights organization can also work to change attitudes and provide legal reform from within the states, which could maybe be more important for the general and the long-term development in this area. So to summarize what I concluded, and I feel like I spoke very fast, but maybe that's good looking at the time schedule. So to summarize what I concluded from this is that the court is actually a more influential human rights actor in Latin America than what its compliance rates might suggest. It serves an important role in safeguarding individual human rights in the few cases that actually comes before it, but it also serves a role in preventing future violation and therefore in achieving a sustainable human rights protection in the region. But of course, this last effect of achieving a long-term human rights protection cannot be solely achieved by the court's rulings. But seeing as it coexists and cooperates with domestic actors, they help to contribute to such change happening from within the states. And that was basically my conclusion from this essay.
Thank you so much, Amalia. Very interesting to hear your analysis and reflections and conclusions. I think this triggers a further discussion of the impact of the court and the system as a whole, including the commission. And I would like to turn to one of our experts in the panel, Per. Per, what are your reflections on this conclusion that Amalia draws regarding the impact of the court? And I would like to ask you also if you can elaborate a little bit on your view of how the system can impact human rights situations and peace and security in countries.
Okay, well, thank you, Sophia, and yep, thank you, Sophia, and good afternoon to you all. It's great to be here, and thank you for the invitation, and thank you to the organizers. But most importantly, thank you to the essay writers for giving us the opportunity to engage with your thinking, your reflections, your analysis of the Inter-American human rights system. And the kind of key contribution, in my view, that you make here is really to kind of spotlight the Inter-American system as an important set of institutions in human rights governance more broadly, right? And I think also, and this is what I kind of my comments here now would like to kind of focus on, is to think about what the role of the Inter-American human rights system is in that kind of more global kind of landscape of international human rights. But really kind of my reflections here now very, very kind of briefly comes out of Amalia's essay. And I think she makes several really quite important points in her essay, and that she now summarized earlier. First is the basic but important point about the centrality of the Inter-American human rights system in the regional human rights politics of the Americas, and in particular in Latin America over the decades. And this is a basic point, but it's so important that if you want to think about human rights politics in the region, the Inter-American system is a central actor in that politics, right? The second has to do with the demands on the Inter-American human rights system and how these demands have exponentially increased over the years. And I think, and Amalia makes these points as well in her essay, it reflects at least two things. First, the kind of perceived relevance of the Inter-American human rights system for human rights actors across the region, right? It matters. Second, that there are increasing expectations for those who are suffering from human rights abuse, that somehow the Inter-American human rights system can actually assist them somehow, yeah? The third point that Amalia makes in her essay that I think is really important and interesting is that despite these increasing demands on the Inter-American human rights system, or perhaps more accurately, because of these demands, the state responses as measured in kind of compliance rate by the or compliance rate with court rulings remains patchy at best, right? So this leads us to kind of the fourth central point, right, which is the central paradox in many ways for many. And this is the kind of paradox that is captured in the kind of problem here that Amalia identifies around low compliance rates, okay? So effectively the gap between high expectations and low satisfaction, right? As measured in low compliance rates. And this should prompt kind of questions here as to what the Inter-American human rights system actually offers those who are concerned with human rights protections in the Americas. And it's precisely this point, which I kind of call the impact of the Inter-American human rights system beyond compliance, that Amalia engages with in her essay. So how can we think about this question, impact of the Inter-American human rights system beyond compliance? Now, I'm kind of generally tempted here just to ask you to go and read Amalia's essays up on the Foundation's website. So, you know, go and read it and reflect on the analysis and the conclusions, right? But that was a bit too easy for me, I guess, to kind of just get away with that. So I would like to kind of just make a few important points, at least to me. And here I would like to emphasize the contributions of the Inter-American human rights system, not only to its immediate region, if you like, the Americas, but also human rights governance more globally. So the first point to highlight, and I've already alluded to this, and this is not a minor point in my view, is that the very existence of the Inter-American human rights system is important, right? Diego already alluded to, or we can refer to this kind of long historical, relatively long historical institutional development of the Inter-American human rights system. And it reminds us, you know, from the starting point, if you like, of the modern kind of starting point of the Inter-American human rights system in 1948, that how deeply connected the Inter-American human rights system is with international human rights more broadly, right? And this, again, I think is an important reminder that international human rights, or human rights, is simply not just the result here of kind of an imposition from the global north, the west, however you want to kind of geographically map these kind of conflicts now, if you like. And it shows that the kind of the Inter-American human rights system is a kind of central protagonist in the emergence and consolidation of global human rights governance over decades. And I think this is an important reminder here that some of the central ideas about what we think about when we talk about human rights here comes out of the experience of the Inter-American human rights system. The second point, I think, has to do, and here I really would like to defer to Diego, really, because he's the real expert on these matters. But the central point here, I think, is with regards to the normative construction involving interpretations of international human rights standards and international human rights norms. And here, the Commission and the Court perform crucial functions in the development of human rights standards, right? So what standards are and how they should be understood. So Amalia referred to this in her essay, but it's well known that the Inter-American Court, of course, has developed a generally quite a progressive human rights jurisprudence on many measures, a far more progressive, more expansive human rights jurisprudence than the European Court of Human Rights. The Commission as well, of course, has an important function here in contributing to the development of soft law through its thematic reports, as well as various policy guidelines. And that perhaps four key areas where this has been particularly interesting. Transition justice jurisprudence. The Inter-American system has been at the forefront of transition justice. Amalia referred to its amnesty jurisprudence here. And really, through the Inter-American system's dealings with transition justice has given rise to a broad set of state obligations, right? And in particular, the Inter-American system, as Diego has written extensively about, has put a very strong emphasis on issues of accountability or anti-impunity, right? And effectively confirming that states have an international obligation to ensure accountability for human rights violations, establish truth, repair harms in the aftermath of human rights violations. So kind of the response here with an emphasis on accountability to human rights violations. Second area that is, I think, interesting and important to highlight is the contribution of the Inter-American Court, but also more generally the system, and in kind of reconceptualizing gender-based violence. The kind of notion here of feminicide is particularly, I think, important in terms of defining what it means and the scope of state obligations. Of course, entering into areas that have kind of previously been understood to be in the kind of private sphere, and so on and so forth. Kind of emphasizing the discriminatory character of violence against women in many contexts. A third example has to do with the kind of this enmeshment between, if you like, classical traditional civil rights, such as right to life, and social rights in the notion of a dignified life, the vida digna, right, that the court has emphasized over the years, right? So again, this, I think, is an important contribution to thinking about not so much kind of socioeconomic rights and civil political rights as being kind of separate, but actually thinking of them in a kind of a contextualized and, I think, quite engaging with the lived experiences of how these violations actually affect people in their lives. And the fourth area to highlight in terms of normative and development of standards has to do with indigenous rights. And of course, famously, the kind of landmark ruling that I was digging in Nicaragua, we'll come back to Nicaragua, I'm sure, later on. But with regards to land rights and the kind of interpretation of land rights in a kind of collective sense by the Inter-American Court. So again, these are areas in which the Inter-American system has contributed not just in its region, but globally to our understanding of what international human rights standards are about, how we could and should perhaps think about them, as well as what obligations states and other relevant actors may have in ensuring not just that there are reparations, but that there's kind of prevention in place, or mechanisms of prevention in place to ensure their non-repetition, right? The third, and I'll just kind of end on this, I guess, kind of coming up on time right now because I'm getting so eager and into this discussion, right? But I think what another kind of third area that is important to think of the Inter-American human rights system in terms of impact, right, is what it kind of represents. It represents kind of impact in, let's put it mildly, in a region where this is really tough and often very inhospitable kind of conditions. So Diego and Malia refer to kind of the past, dictatorship, civil war, and so on and so forth. But of course, we have a present that also in many ways is inhospitable in many instances. It has to do with violent democracies, as some refer to, but it's also to do with very, very significant political resistance to human rights, both as a notion and as a particular form of politics. And we'll, I'm sure, come back to this point. And despite this, the Inter-American system has developed important accountability functions. The Commission and the Court regularly monitor and evaluate human rights performance of states. The Inter-American system is an important advocacy actor in itself. And the Commission has developed a really broad range of tools that kind of Diego referred to earlier. And this is kind of one of Amalia's important points, right? That the Inter-American system performs kind of an indirect advocacy role here, but effectively providing what I call a platform for human rights mobilization, right? And some of these organizations, civil society organizations, various associations have become very, very strategic in their use domestically of the Inter-American human rights system. So it's not just a court, it's not just a commission in Washington, D.C. and San Jose, Costa Rica, respectively. It is actually a system that is present in uneven ways, for sure, but present in the region that it has jurisdiction, right? And I think this is what to me is the kind of the take-home point when thinking about the Inter-American human rights system. And for sure, we'll come to the many challenges, I'm certain, right? But I think at least pausing for a moment to reflect on what are very important contributions of the lineup of Amalia kind of and the other essay writers kind of are highlighted in their contributions, and what I'm trying to emphasize here, it is important and kind of a source for hope, right? Not just for the present, but for the future as well. So thanks again for giving the opportunity to read the essays.
Thank you so much, Per. I think you make very interesting points, and it's clear that the system, both the Commission and the Court, has been quite successful in several cases. And but still, as you mentioned, and as we have heard, there are many challenges facing the system, and its power and influence in certain situations can be rather limited, right? While Louisa has, in her essay, looked closer at the situation of crisis and how rights guaranteed in the American Convention on Human Rights, for example, can be suspended in certain situations. Louisa, could you please share some of your findings with regards to people's access to their rights in emergencies, for example?
Yes, sure. And I want to start to thank you for the ability to participate in these seminars, and also thank you for organizing this seminar on these very important subjects. Yes, so the title of my essay was Suspension of Guarantees in Emergencies and the Role of the Inter-American Court of Human Rights to Protect Human Rights. And the purpose of my essay was to examine what protection the American Convention on Human Rights offers in emergency situations. And as a short introduction, in Article 27.1 in the American Convention, it is stated that a state can derogate from its responsibilities in the American Convention in times of war, public danger, or other emergency that threatens the independence or security of a state party. And in accordance with Article 27.2 in the American Convention, a state cannot derogate from some rights, as for example, the right to life. The judicial guarantees that are essential for the protection of those rights can't be suspended either. So what protection do the American Convention offer in emergency situations? Against the fact that the American Convention contains the most non-derogable rights, compared to the UN Convention on Civil and Political Rights and the European Convention on Human Rights, it can be claimed that the Convention offers the best human rights protection. Yes. There's no requirement of judicial guarantees with consideration to the non-derogable rights in the wording of the UN Convention on Civil and Political Rights and European Convention on Human Rights, which it does in the American Convention. And in my opinion, thus the wording in the American Convention involves a strong signal to the state parties that it must not only protect some rights, they also need to secure the effectiveness of the judicial processes. In the judgment of the Inter-American Court in the case habeas corpus in emergency situations, it is shown that even when a suspension has taken place, the American Convention is still an important instrument to protect human rights. The rule of law and the principle of legality still exists and needs to be upheld. Through the case, two guarantees become non-derogable. to the right to habeas corpus, which is prescribed in Article 7.6 in the American Convention, and amparo, which is prescribed in Article 25 in the Convention. And they are rights that are normally derogable by Article 27.1. And another important case is the case of judicial guarantees in state of emergencies. And that case demonstrates that even in a state of emergency, the principle of due process must be respected. Because of all judicial guarantees in Article 27.2 cannot be listed, it is possible to expand judicial guarantees to more guarantees in the court's case law. And the mentioned case also shows that despite the fact that the Article 8 in the American Convention is not listed as a non-derogable right, it is still importance in emergencies with regard to the essential judicial guarantees. So what role has the Inter-American Court in emergencies? The judgments of the Inter-American Court have had an impact on the respect for human rights in emergencies. Through the court's case law, for example, the case habeas corpus in emergency situations, the court has strengthened the protection for human rights in emergencies. And my conclusion, my essay, was that despite the fact that the American Convention gives the states parties the possibility to temporarily suspend the full and effective exercise of the rights in the Convention, it is still an important instrument in emergencies. Yes, with the demands prescribed in Article 27.2 in the American Convention to respect the essential judicial guarantees to the non-derogable rights, the individuals has a chance to safeguard its rights. Yes, and that was all for me.
Thank you so much, Louisa, for sharing your insights. Very interesting to hear. Well, to further explore the limitations of the inter-American system and the OS in the promotion of human rights, peace, and security, I will now ask Helmer if you can share some of your reflections and conclusions from your essay, which looks into the mandate and legal possibilities that the system has to intervene in situations where there are ongoing human rights violations, for example, as we see in Venezuela. The floor is yours.
Thank you, and I will also like to thank the Swedish Foundation for Human Rights for hosting this, both the essay competition and this seminar, and for inviting me and Lovisa and Amada to participate. My take on this year's theme was rather different from Amalia's and Lovisa's. My interest in public international law lays in the laws of war. So that was where I started out. And during my research, I added more of a human rights perspective, but the focus of my paper has clearly been the peace and security part of this year's theme. But war is, of course, interlinked with human rights. Courts and commissions can only do so much to stop human rights abuse. So if it comes down to it, the last resort for the international community is always to act with military force. So my take on this year's theme was thus the possibility for the Organization of American States, the OAS, to conduct a military intervention in case of human rights abuse. And as you said, I initially focused on the situation in Venezuela. I had read that the Secretary General of the OAS had not ruled out a military intervention there. So I thought that it would be interesting interesting as well as topical to focus on that. But after running out of words, I had to kill some darlings and focus more on the general issue of whether the OAS has the power to conduct military interventions at all, and if so, on what grounds. So basically, the OAS has only conducted one military intervention, so that was naturally where I began. There was a civil war erupting in the Dominican Republic in the 1960s, in which the United States intervened to stop the Dominican Republic from turning communist, as Cuba recently had, there was a ceasefire agreement reached, and the OAS created a military force to see to that that ceasefire agreement was being honored. And in relation to its own charter, the OAS argued that while there was no express power to intervene militarily, there was also nothing in the charter that prohibited such action. So since one of the purposes of the OAS is to establish peace and security, the OAS considered itself competent to conduct a military intervention. I should note that this has changed since then, and the OAS charter now expressly states that the OAS does not have any power that is not conferred to it by its charter. So there, the story is kind of over, and so would my paper be. But because of the fact that the intervention in the Dominican Republic was conducted on legally questionable grounds, coupled with the possibility of another amendment to the OAS charter, and most important of all, the remarks by the Secretary General that a military intervention in Venezuela was not ruled out, I continued my paper and my research focusing on the United Nations, the UN, and the prohibition on the use of force. So if the OAS found a way to justify a military intervention on account of their internal legal system, how then would such action be regarded by the UN? And at the moment, it is quite clear that regional organizations such as the OAS need authorization from the UN Security Council before initiating military interventions. However, this requirement is not adhered to as strictly anymore. And for example, the African Union has initiated military interventions without such authorization, although always receiving it afterwards. The African Union is also in the process of creating its own military force, the African Standby Force. And although it has promised to still ask for authorization from the Security Council, concerns have been raised that the African Union might not take no for an answer. So then if the question is raised, does the African Union, in the way that they have organized this task force, still need Security Council authorization, or has it found a way to circumvent this while still adhering to the charter of the UN? So basically my conclusion was that at the moment, there is no legal ground for the OAS to initiate military interventions. Its member states, however, are of course free to act outside of the organization, which might be what the Secretary General meant with his remarks. In any case, of course, authorization is needed from the Security Council to use force. But whether this will hold true looking forward, considering the actions of the African Union, that discussion takes me a bit astray from the original topic. So I will leave this discussion today, and I also left the discussion in my paper for my master's thesis for the coming semester. But I will leave you with this thought. If the African Union successfully questions the monopoly of the use of force that has traditionally been in the hands of the Security Council, how then will the OAS react, especially considering the remarks from the Secretary General that, at least to me, suggest that we might see a more militarily active organization of American states in the future? Thank you.
Thank you so much, Helmer. I think that was really helpful and very interesting contribution, not least with regard to the interlinkages between peace and security and human rights, and also the system's relation to the UN and the comparison to the African system. It definitely triggers further discussion, and I'm very happy to hear that it might also inspire you in future essays. We have now finished the first part of the seminar with presentations, of the possibilities and some limitations of the system's ability to influence human rights, peace and security in the countries of the Americas. And we will now invite our panel for a further discussion on the potential impact of the system and current crisis that we see in the Western Hemisphere. And I am now turning first to Diego. And Diego, we have heard that there are several limitations with regards to the protection of human rights in certain situations. And it can seem rather discouraging, right? That in situations where human rights protection is perhaps more needed than ever, the system can be, the system's mandate and abilities can be quite limited. But given your knowledge of the inter-American system and human rights and humanitarian law, could you please explain a little bit or give us your view on how the Commission and the court can impact crisis and conflict situations that we see now ongoing in the Western Hemisphere, and how they can tackle the limitations that we have heard about?
Thank you, Sophia, and thank you very much for all the presentations and very insightful comments and provocative comments, because this is a very interesting topic, you know, in the inter-American system and around the world when we are talking about the responsibility to protect, the notion of humanitarian intervention. You know, it's extremely controversial and it takes shape in different forms depending on the political context in which some of these initiatives are implemented. Let me try to tackle the notion that was suggested of a possibility to interfere in countries' domestic or internal affairs with reference to the responsibility to protect. And the first comment I'd like to make is that when we talk about human rights, really, we are not talking about exclusively domestic or internal affairs. We are talking really about issues that have been internationalized in the post-war, after World War II, and that have been subject to extensive regulation, if you want, by the international community. And again, many of the concerns were born precisely from what happened during World War II. We are talking about genocide, crimes against humanity, war crimes, and it's on the basis of those situations that a lot of what we see right now regarding international human rights law, international humanitarian law, has taken place. So the question from my perspective is basically how far can the international community can go in order to prevent this type of gross violations, crimes against humanity, war crimes, etc., taking into account the existence of the principle of non-intervention under the Charter of the United Nations and several regional arrangements. So this tension that exists between the need to tackle and confront these horrendous situations versus this principle of non-intervention that, again, is extremely important, as you can imagine. And let me mention briefly that I think that the responsibility to protect has several elements. One, as it was basically crafted in 2004-5, it has been dealt with. One, assigning the responsibility of protection to the state under which the jurisdiction of the persons are, the population. So it's a subsidiary, has a subsidiary nature in the sense that if that fails, it's the international reaction will be triggered. And that's the essence of this approach. It basically indicates that in confronting genocide, crimes against humanity, ethnic cleansing, war crimes, there would be collective action that could take the shape, in principle, of peaceful means or diplomacy. And that's what is called upon when we are talking about this notion of responsibility to protect. Should that fail, it opens the door for the notion or action under the auspices of the Security Council Chapter 7 measures that could include the use of force, which means that, again, the international community may be signaling that it does fall, that these situations do fall under Chapter 7 powers of the Security Council, that for some time was controversial, but this appears to reaffirm this approach, but still is subject to discussion. Additionally, the international community considered that the importance of confronting this type of situations required early warning systems and cooperation among international organizations, not only the UN, but also regional organizations. That was a possibility, and as it was suggested by Helmer, for example, cooperation between the UN Security Council and the regional arrangements in the case of the African system. But again, there are several elements that have been dealt with when dealing with the notion of responsibility to protect. This said, in the Inter-American system and in the Americas, I think we have to understand really that there's a very sensitive approach to the principle of non-intervention. And we have to see it in the context of an asymmetric hemisphere in which we have, you know that Central American, Latin American, South American countries, Caribbean, and then we have our friend of the North, the US. You know, the relationship between all these countries and the US is really asymmetric, and this probably is an understatement. And that has taken states in the Americas to elevate this principle into the realm of the Charter of the Organization of American States and its practice. Even before the creation of the organization in 1945, the states have met and called among the nations to reject the use of diplomatic protection. So states protecting their aliens from injury in another state. Even non-military bilateral reaction by states was called into question by states in the Americas. And again, because of this very deep sensitivity that exists in our region regarding possible interventions. I don't have to tell you, you know, the long history of interventions by the US in several countries in different ways, militarily in the Caribbean or in other ways. Chile is a good example. So again, we are talking about this very, very complex relationship of states with the United States. And in that context, I'm sure that Andres is going to be talking a little bit more about this aspect, but I think it's important to contextualize it. Finally, simply to say that I think that in this context is where the human rights mechanisms of the Inter-American system have evolved, and that the reaction of collective response to this type of violations runs through precisely the Inter-American human rights system, the actions by the Inter-American Commission Court, and hopefully by political organs that will receive and act upon what these organs are saying. So that's why it has open opportunities and allows space for these organs to further develop tools that maybe were not acceptable, may not be acceptable in the African region, the European system, or the UN. When I talk about interim measures and this expansive role of this preventive tool may be related to this, in which the Inter-American system reads the context in which we are talking about how to confront this type of violations, and it basically legitimizes further the power of the peaceful collective reaction through Inter-American human rights law. Simply to provoke a conversation, I already mentioned the powers of the Commission, the court, the expansive role, the possibility of on-site visits. When we talk about Venezuela, the deploying of Commission members to the border of Venezuela in other contexts may be seen as an intervention in the domestic affairs of a country. In the Inter-American system, really, it's not there are no big questions regarding the power of the Commission to deploy itself into the jurisdiction of a state with, of course, the consent or acquiescence of states, or at least to be able to approach it in the way it has been done in Venezuela and others. I will leave it there, I think, and would like to hear your comments and reactions to of the papers that have been presented and engage in this conversation. Thank you very much.
Thank you so much, Diego. Really interesting, and I'm sorry that we don't have enough time to let you tell us more about this. It's really interesting indeed. But I would like to turn to Andres and Per, if you would like to share your thoughts also on the potential impact of the system and the ongoing crisis that we see now, for example, in Nicaragua and Venezuela. What other aspects do you think we can consider with regards to political or power relations between member states of the OAS? Well, Andres, would you like to start? Andres?
Now, can you hear me?
Now. Yes.
Right, thank you. Well, thank you very much. It was really a joy to listen to everybody. I am really glad, particularly glad to hear about the students writing on these issues. Let me just say a brief thing on this. That for these students, you are actually part of a long tradition in Sweden on writing on these issues. Actually, I brought up here. This is the things. I don't know if you can see it. This is a thesis wrote in 1922 about Fredrik Johannesson that is called the Panamerikanska problemet in Swedish, the Pan American problem. And the tutor of this Fredrik Johansson was actually a famous scholar from the Uppsala University at Christianum professorship, namely Rudolf Kjellén, the inventor of the concept of geopolitics. There is actually one room in the Christianum building which has his name, and he has a particular chapter in his book which is called The Great Powers, Stormakterna, which was one of the first books writing on these global issues. He called it planetaric issues, that is about United States and actually touch about this American issue. There was a large interest on this since actually since the 19th century in Sweden, particularly by the Germans. The Swedes took a lot from the Germans that study a lot on the Pan-American issue, the Pan-American system. And now one of the reasons is that the Pan-American system is one of the oldest regional systems in the world. So that's also one of the reasons I'm particularly glad that you are looking upon this issue, because there is an acquisition of knowledge and elements that have been built up in this region that I think are important for the region, and I think are important to analyze from even from a global perspective in the construction of these regional systems, particularly in the area of the human rights, which is what concerns us here. So actually, that is my point of departure. I do believe that in spite of the crisis, in spite of all the problems that you actually mentioned, Per talked about the inhospitability of the region in this sense. I totally agree that right now we see a crisis for all the regional systems in the hemisphere, not only the inter-American, also the Latin American systems, the Mercosur, the UNASUR, the CELAC, all the sub-regional ones. There is a big stall in this sense. Nevertheless, I think that the build-up for decades, all those more than a century of these systems, I think it's there. It do plays a role, as you have noticed in your papers, and I do believe that it will play a role in the future as well. And the thing is how, and that this is a constantly changing issue. And why is it changing? Because it has very much to do with the relations, the power relationship with these countries. And in this sense, I want to take up actually the thesis of Johannesson, because this speaking about the Pan-American problem, which actually I think should be the American geopolitical problem, is still there. A problem for on which way to go. There is a contradiction within the United States, and there are contradiction or dichotomies with United States and the Latin American countries that are still not resolved, and we will see which path it takes. Within the United States, it's the two paths. One is what I would say the Monroe Pact, which is originated in the idea of around the Monroe Doctrine, which is basically an hegemonic idea of the United States exerting its powers towards the hemisphere. In the US, foreign policy scholars speak about the Republican empire, which is basically the relationship that the original 13 colonies building up the integration project that was United States, a successful one, have had hegemonic, sometimes imperialistic positions towards the other territories, to start within North America and then to the rest of the continent. And this is very much what is within this Monroe Doctrine outlook. But there is another view, which is a more integrative one that have existed all along the way. That is the one that was present in 1889, which was in the Washington Conference when the Pan-Americanism was actually born. At that moment, the idea was not to create a hegemonic project. It was actually a true integrationist project. They spoke about a custom union. They spoke about a common currency. They spoke about regional banks. Some years later, that was what is today the Inter-American Development Bank, the IDB. So all these issues were present at that time. So since then, within the US, we have seen these two policies, the more integrative one present, for example, in Delano Roosevelt's Good Neighbor policy, present in the Alliance for Progress promoted by President Kennedy, present very much in the Summit of the Americas process that was initiated during the 1990s, and somehow also in the original idea from 1948 in the creation of the Organization of American States. At the same time, we have seen the Monroe idea present in all this. We have seen that in the imperialist, invasion-oriented outlook towards the Caribbean, towards Central America. Diego mentioned something like that. The backup of military regimes in Latin America through the national security doctrine, that was an hemispheric doctrine also, that was Monroe. And that we have seen today in for example, when Trump actually reinstalled the Monroe Doctrine that Obama took away, it was with the idea of, in a way, threatening the Latin American countries of not having autonomous policies towards what the United States perceives as enemies, which was in this case was China and Russia. So there we have these two things. And there is this other dichotomy, which is between mainly the Monroe Doctrine idea and the Latin American doctrines of integration. And here we have the Latin Americans' ideas of regional integration and creating regional systems that were created, for example, in opposition of the Roosevelt corollary to the Monroe Doctrine in the early 20th century. That this was this idea of speaking softly and carry a big stick, if you remember. Here we have the Drago Doctrine from the Argentinian lawyers and specialists in international law that were pointing out towards the autonomy and the right of sovereignty for these countries towards the big powers such as the United States. And these ideas have been present all along the way, this need and the preservation of autonomy from the Latin Americans. So I think these dichotomies are the one that we are still seeing today in the system. And just to end up here, in spite of all this, I think we have to acknowledge that the system has been continuous building up throughout the way and build up in new dimensions, the human rights dimensions, the Santiago Declaration from the 1990s, all of those are important elements that you have pointed out in your papers and in also the presentations from Per and Diego. And this, I think, is something that needs to be taken with care and with attention. Thank you.
Thank you so much, Andres. And that was very interesting to hear. Well, now I would like to say, before handing over to Per, I would like to hear your reflections as well, Per. But first, I would just like to say that we are now opening up also for questions from the audience. So please post your questions if you have. And I would like to take one of the questions already now before you give your reflections, Per, because I think it's quite connected to the discussion that we are having. And it's regarding Nicaragua, and it refers to the human rights violations that we have observed during the last couple of years in the country. And the question is, what is the Nicaraguan government's legal obligations with regards to the Inter-American Convention on the Human Rights System, and how can the government be held accountable for these violations? Can the families ever achieve justice, and how? And so I'm handing over to Pa to give your reflections, and if you can also comment on this question.
Yeah, thanks, Sophia, and thank you as well for the question regarding Nicaragua. I actually want to say a few things about Nicaragua in light of the kind of ongoing discussion here. But the way we can think about Nicaragua and Venezuela, which I think are the two kind of situations here, country situations that Sophia highlighted earlier as kind of crisis situations. I think it's always important to think about what we mean by a crisis, and whether crisis, of course, gives a sense of emergency, which obviously there is. But it's also important to recall that we tend to constantly talk about crisis when we talk about human rights in most settings, right? So to try to think about what is it that we mean by crisis, and what is it that the Inter-American system can actually do in response. So my take on this is fairly basic, right? And one, the Inter-American human rights system is not a crisis response institution, right? And it will not work very well when it's used as such. Nor is it a conflict resolution or political mediation tool, right? So I kind of alluded to earlier that, in my view, the potential of the Inter-American human rights system to promote and protect human rights and to work for societies that are peaceful and just, this utopia that we have across the world, right, wherever we are. I think its potential of the system is greatest when certain conditions are met, right? And what are those conditions? Well, there is a demand from those that are affected by human rights violations. Two, there is a minimum degree of political acceptance and political recognition of the role that the Inter-American human rights system can play in responding to human rights violations, or to kind of providing a way forward, if you like. And three, on the part of the Inter-American system itself, there is a kind of an active, a well-informed analysis by the Inter-American system of the country situation or the specific human rights concern that the system is engaging with. So when these basic conditions are met, the potential of the Inter-American system is at its highest to make a positive impact on the human rights situation concern. Now, in relation to Nicaragua and Venezuela specifically, I think these conditions are partially met in the case of Nicaragua, and only barely, if at all, met in the case of Venezuela, right? So in the case of Nicaragua, which is both important and interesting historically, as well as present in the present situation. So one, there is a high demand from civil society groups across Nicaragua. The Inter-American Commission, as I think Diego highlighted, has conducted visits. The former executive secretary of the commission, Paulo Aldrao, made several high-profile kind of interventions and visits, engaging with civil society actors at various points, following the kind of initial outbreak of public protests against the Ortega government. Now, despite the very strong rhetoric of the Ortega government against the commission, there has been some degree of recognition of the potential role, at least initially. Now the work on the ground is somehow temporarily suspended. The Inter-American Commission developed a kind of an innovative approach here in addressing the situation, in creating a special mechanism, monitoring mechanism for Nicaragua, though of course it's difficult to assess this kind of impact, right? I think the Inter-American Commission's response to the political conflict and the kind of associated human rights violations have been quite focused, in my view, which is helpful. And the kind of focus here on the human rights issues that are at stake in the context of social protests against the Ortega government and the repression that has ensued. So overall, in this context, the Commission can potentially play, and has played, a kind of a role here in both highlighting, spotlighting the kind of violations, challenging government narratives as about who's responsible for violations, as well as serving that kind of role of delegitimating an oppressive government response to the situation. In the case of Venezuela, I think, in my view, this is a very different scenario. And I should add, and this is kind of highlighting what was previously mentioned about geostrategic dimensions to it. The stakes are dramatically different when it comes to Venezuela. geostrategically. So what are some of the conditions here? So to the extent there is a demand from civil society groups and society across Venezuela, of course, but the repression in Venezuela has been sustained and severe over a long period of time. And moreover, the complexity of the humanitarian crisis in Venezuela makes the situation very difficult to address, right? Also, there are problems, in my view, with relying on exiled groups in addressing what is a kind of political and human rights crisis in the country. Also, there's been a long-standing outright rejection of the Venezuelan government of the inter-American system. This is long-standing and predates the current crisis situation. And also, to think about the OAS and the inter-American system, the lead on Venezuela by the OAS, which of course the inter-American system is part of, has been effectively by the OAS Secretary General, Luis Almagro, and effectively on many occasions bypassing the inter-American system outright, including convening ad hoc expert groups to document human rights violations in Venezuela. So the framing of the situation in Venezuela by the OAS, right, has been one of kind of a top-led approach that has framed this in terms of international criminal justice, not a human rights situation necessarily, as well as a very kind of confrontational politics that is fueled both by the Venezuelan government for sure, but as well by Almagro himself, and effectively has made any kind of political mediation role practically impossible. So the prospects here for the impact, kind of positive impact in the case of Venezuela is fairly slim in my view, both by the inter-American system and the OAS more generally. So I think we need to set up expectation, understanding what the inter-American system is, what we're actually talking about, the situation on the ground, the crisis, if you like, and what can be done in that respect.
Thank you so much, Per. And before handing over to Diego and Andres, to ask you if you have any additional comments or reflections with regards to this and the Nicaragua case in particular, I would also like to ask if you would like to perhaps respond to the question if there's a potential for the system to play a more prominent role with regards to the issues that we are discussing with human rights and peace and security in the future. So if you have any final reflections, Diego and Andres, before we go to the last section of the seminar.
Thank you, Sophia. Well, no, very briefly, I think that the inter-American system indeed, depends how you understand it. The Organization of American States, again, because of this asymmetry with the US, will be seen with suspicion if there is any type of move towards any military or similar intervention regarding one of the states of the Americas. There is resistance. That's why, as Par mentioned, there's resistance within the General Assembly, and basically the Secretary General will have to overpass. We'll have to do things on its side, because if it goes to the normal governance mechanisms, there would be resistance towards any type of measure that could entail intervention. And that also explains why states are ready to accept some of the actions taken by the inter-American human rights system regarding crisis situations, if we want, like Venezuela or Nicaragua. And that's an opportunity, for these institutions to a certain extent, expand their role as they have done so. There is an understanding, I think, in the inter-American system that states do prefer to have many of the issues channeled through the inter-American human rights mechanisms, and to validate them, because if you undermine them, then we'll go into the realm of real politics and the reign of the powerful. And guess what? I think the answer would be automatic. So there's an understanding in the Americas that the inter-American system plays a role, but there's an understanding that it should be a limited role when we are talking about, for example, these notions of humanitarian intervention, which can be used with spurious objectives. Again, that said, of course, there are political processes that have taken place in the region, such as the Grupo de Rio, the Rio Group, and others that intervene extra OEAs in certain situations of crisis, precisely because it would not necessarily involve the conversation of this asymmetric relationship. It will bring other actors. It will elevate the importance of other regional actors different from the US. So the Grupo de Rio, or the subregional CELAC, UNASUR, playing certain roles on specific situations as an ad hoc intervention. So to that extent, that's the political reaction. I personally don't see any endorsement to, for example, using the OAS as the vehicle of a Security Council, Chapter 7 order of intervention regarding any state in the Americas. If it happens, it will be implemented in another shape or form, not necessarily the Organization of American States. And again, I'm very skeptical that there will be broad acceptance of such a tool in the hemisphere. But again, I think this is the subject matter of these discussions. So that's the only thing I wanted to state in this regard. Thank you.
Thank you. Yeah, Andres, anything that you would like to add or reflect on?
No, well, I very much agree with what Diego said now. I think there is, in how to go forward with this, there is a problem of legitimacy in all the system. And this is what I said earlier on, is a geopolitical problem among these countries, but it's also where to go. At this moment right now, at this juncture, I think there is a lack of vision. The United States is not pointing the way to go, where to go into an inter-American way. The last vision on this line, constructive vision, was the one of President Bush's father, was the initiative of the Americas in the early 90s that started the whole process of the summits of the Americas, was free markets and democracy. That initiated also an expansion of the OAS and the inter-American system. But those issues confront all the time the suspicions from the Latin Americans and has not been followed up by United States in a way that might lead to a stronger attachment for the inter-American system. Actually, I note some of the comments that were said that link up the issue of human rights only looking at Latin America. But the thing is that if the inter-American system would have legitimacy in the future, it must also be looked up to United States itself. Otherwise, it would only be a continuation of the idea of the Monroe Doctrine, that is United States over Latin America, and not to have an integrative system that would be something leading to more legitimacy concerning the perspective of the Latin American. So all these suspicions still lives there. And I think the decision and the path marked by United States in this way will be extremely important. I am expecting to see what President Biden will have for vision on this subject. Otherwise, I am afraid that the lack of support for these regional instruments will continue. And this is also something that is fragmenting the Latin Americans themselves, because we see this fragmentation that have existed between the ALBA countries, nowadays the Grupo de Lima, the contact group, and so on. So the Latin Americans themselves have to, in a way, look internally on what they want and try to foster their own systems and build up again to see in what direction it takes. For as it is today, none of the systems are really working in practice to solve the conflicts, such as the Venezuelan one. And this should be a priority. I don't think there will be progress in terms of regional integration if the Venezuelan issue is not solved.
Thank you, Andres. And thank all of you for this very interesting discussion. Unfortunately, we don't have time for more questions or further discussion, even though it would have been very interesting to continue the discussion. We have to move forward to the last part of our seminar, and I would like to encourage you to please answer the survey that we have linked in the chat. It will only take a few minutes, and we would be very happy if you could take a bit of time to do that. Now we have reached the final part, and I would like to turn to all of the finalists, all three of you, to ask you about the competition and the theme. If you had any previous knowledge about the system, and what have you learned that you think can be useful in your future studies and work? anyone who would like to speak, please go ahead.
I can start then. Someone has to be the first. I didn't have too much previous knowledge, I would say. I did study a course, a semester in international law this last spring, and we touched upon the inter-American system, but I would say that my knowledge about it has deepened tremendously during this past summer researching. And I would also say that it's great that there are organizations that try to engage students in other legal matters other than business law, which is usually what the possibility that you have to engage as a student. So once again, I would like to thank you for hosting this competition and making us students realize that there are opportunities to work with human rights and international law in general going ahead. Yeah.
Yeah, I agree with Helmer. We study at the same course this spring in international public law, and yes, we touched it very briefly, the inter-American system. So and I think also during the law program, you usually just normally focus on the European system and the European Convention on Human Rights, and not the inter-American system or the African system. So I think it's the competition was a great opportunity to open your eyes and get knowledge of other human rights systems. So I think it was very interesting, and yeah, I learned a lot, and I think I will it is a knowledge that I will carry on in the future and my career, and yeah.
Yes, well, I can just agree with both of you, and I specifically what Helmer said. I think this is a great opportunity for students interested in, well, international law matters and human rights questions, so that's great. I, unlike the other students, I haven't done international law or as much. I'm currently studying international law, but it's a bit shorter course, which will not touch upon the subject of regional institutions at all. So I've studied constitutional law, so I had experience from the European Court of Human Rights more. However, I've studied a semester in Buenos Aires in Argentina, so my interest for this particular essay competition came more from, well, the interest of the Latin American region. So I came into it actually wanting to write about more about the dictatorship era crimes, since I had that particular interest since my time in Argentina. But I learned a lot, and I actually found this whole experience has been very, very, it has shaped some of my future ambitions, and I'm thinking maybe to move on a little bit more to international law after it. So it's been a great experience.
And if I can add, it's also going to be interesting to see next year's theme, considering that last year was Africa and this year is Latin America. Which region is up next?
Yes, thank you so much, all three of you. I must say I'm very impressed by you today, and by reading your essays and hearing you engage on the different themes of this year's competition. It has been truly interesting and rewarding for us as well. And now, before closing the seminar, I would like to hand over to Pat, one of our jury members in the essay competition, who will present the winner of the competition.
Well, thank you, Sophia. And again, thanks to all three essay writers and contributors. I think based on what you say in terms of all your experiences preparing the essays and engaging in this discussion here, just kind of, as I said earlier, highlights the importance of thinking about the Inter-American human rights system in the kind of broader international human rights law and institutions. And I'll make the plug for Diego and the Washington College of Law, in his place, right? But if, this is an excellent place to study the not just Inter-American human rights system, but actually regionally, thinking about international human rights regionally. And I think Diego posted in the chat some kind of further information on this point, right? So this is not just for the panelists, but for any audience members to go and take a look at the really leading and excellent work that the Diego and his colleagues at the Washington College of Law have been developing from over many years, if I may say so, Diego, right, on the Inter-American human rights system, but also more generally, right? So that's really good to hear in terms of all the motivations and kind of the inspiration I hope that you have got, all of you, from this experience. So we're coming to an end, and the kind of perhaps most important, well, not the most important, but a very important part of this is, of course, to congratulate the winner of this year's essay competition, so Amalia Fantanel, for her excellent essay. So I speak on behalf of all the 3 jury members that enjoyed reading all the essays. That Amalia's essay was incredibly well written and very well argued essay that for the jury members showed a very particularly good and nuanced understanding of the institutional setup of the Inter-American human rights system, getting both a sense of the kind of potential as well as the limitations, and the kind of engaging with a kind of clear problem, if you like, in the terms of the promotion protection of human rights, the issues around compliance, identifying what the problem is in Amalia's understanding, as well as kind of highlighting kind of ways in which to rethink or reshift your understanding of what this problem might consist of in terms of what of the impact of the Inter-American human rights system, to think about not simply in a matter of compliance, which of course is an important metric, an important way of the ways in which the Inter-American human rights system can make a difference, but also thinking about the kind of a broader spectrum of kind of impact that the Inter-American system has. So it was an incredibly accomplished contribution, and I'm very pleased to see that the essay is available on the Foundation's website. So I encourage everyone to go and read the essay and engage further in the work of the Commission of the Inter-American system. So many congratulations to Amalia, many congratulations to all contributors, and I look forward to reading and engaging with you in the future. And I think all the jury members feel the same. So well done, end of a year that has posed many challenges for most people, and I think I take some really kind of heartening thing out of this, and that is that there's hope, and there's incredible resilience when we talk about human rights and human rights protection. That's something that I think is important to retain. So fill in the survey and keep the hope up, and better times will come. Yeah.
Thank you so much, Per, and congratulations, Amalia, and congratulations to all of you. We are now about to end the seminar, and as Per also reminded you, please fill out the survey posted in the chat. I would like to thank all of our participants, our essay competition finalists, Amalia, Lovisa, and Helmer, for your great presentations, which gave us interesting insights and perspectives on the work of the Inter-American Commission and the court and the human rights system as a whole. And a big thank you also to our panelists, of course, Diego, Andres, and Per, for helping us to further explore and discuss the possibilities and challenges facing the system and what actual impact the system has had and might have in the future for peace and security and human rights. And I would also like to encourage all of you listening in to the seminar to further explore the publications by our experts on this topic and related topics, if you wish to learn more. And lastly, thanks to all of you who have taken the time to join us today. We hope you have found it rewarding and that you will continue to follow us, the Swedish Foundation for Human Rights and the Nordic Institute of Latin American Studies on Facebook and through our website. Well, I wish you all a good evening and or a good day, depending on where you are, of course. Thank you so much. Bye.